We'll just give it a minute for the last few people to turn up. That's the hour has just gone. But we will start with the introduction ahead of the cases. So my name is Piers Digby, and with me I have Robert Lee, one of our newest tenants, who is here to display off the skills that so aptly won him his tenancy. And we will be going through the top 10 cases of 2023. Now, we will be trying to cover an equal spread of our sort of private client and property areas and our insolvency areas. And the format we'll be trying is perhaps a little more conversational this time. We'll be bouncing back and forth, taking the cases in turn. And we plan to deal with property private client first, and then insolvency second up. So if you have a particular interest area, then you do feel free to sort of tune in specifically for that. So with all of that in mind, and given that there has now probably been enough time, I will move on to the substance. So we will start with our first case, which is going to be guest and guest. Now, I should say very quickly at the start that technically this did actually have its judgment released in 2022, but it was right at the end of the year, such that we couldn't include it in the previous year's review. And of course, the law reports came out in 2023. So you'll have to give us the Christmas gift of allowing this one, as it's a very important case and deserves inclusion. So what was guest and guest? Well, this was a fascinating case because it was surprisingly the first time that the issue of the remedy in proprietary stoppel cases had actually reached the Supreme Court and had proper consideration. And before this, there had been a sort of dichotomy in proprietary estoppel cases with different judges leaning on different sides in favour of two different forms of remedy. The background in guest and guest was the classic background, farmer and son, the promise that one day, if you work for me, all of this will in time be yours. And lo and behold, the farmer's son did work on that property, starting in 1982 from when he was 16 and continuing up until 2015 when he was almost 50. So, a very considerable 33 years of his life there, given up in pursuit of the promise made by his father. Now, the matter arrived before the trial judge and proprietary estoppel was clearly made out. The promise was plain. The question was, how was the remedy to be decided? The arguments were, on the one hand, the promise was that he should get his share of the farm, therefore the court should uphold that and give him his share of the farm. And that's the expectation-based remedy, making sure that the expectation is performed. And the father's case was, look, he should be compensated for the detriment. It's fine for us to go back on this promise, provided that all of the personal costs and loss of opportunity that was taken on by the son in following the promise is compensated for. And that would actually make a very substantial difference in some cases where perhaps the reliance is slight and the promise is very large. Now, bouncing up eventually to the Supreme Court following the trial judge's decision. The trial judge's decision was interesting because there is a brief summary of the principles where, without too much further consideration, the trial judge effectively says the son is to receive 50% of the farming business and 40% of the proceeds of sale. And that was modelled on an earlier will of the father. So very much taking the expectation route. And when that came to the Supreme Court, in a case put by Thomas Dumont KC of a certain Radcliffe Chambers, the court was actually split on it. And we had a majority decision with three of the judges written by Lord Briggs and a minority decision written by Lord Leggett. Now, in respect of the majority judgment, they were very much concerned with dealing with the minimum equity principle, which stems from Crabb and Aaron. You can just see that on the slide there, where Lord Justice Scarman had noted that the minimum equity to do justice to the plaintiff was the appropriate remedy. It's termed the minimum equity principle. And so the way that was presented to the Supreme Court was, look, you figure out the amount you're going to need to compensate the detriment, and you figure out the value of the expectation, the promise that's been pulled away. You see which one of those, would be the smaller one to remedy, and that's the remedy that the courts provide. And that's how we can reconcile the fact that there's a number of judgments in which detriment has been looked at and a number of judgments in which expectation has been looked at. The Supreme Court majority decision rejected this. They said this is a remedy that's very clearly based around preventing the unconscionable conduct. So the purpose of the remedy should effectively be to undo that unconscionable conduct. And the unconscionable conduct was the resiling on the promise, given that it had been relied on. So the starting point should be enforcing the promise, although there was a need to perhaps adjust a little bit, if necessary, if it would be totally out of proportion with the detriment. Now, the minority decision was interesting because it very strongly argued against that. And there's some academic articles discussed, which are referred to on the slides, effectively saying that, look, the majority decision is going to lead to rather uncertain outcomes. If you're starting with expectation and then fiddling about a bit based on detriment, then it becomes very difficult to know going into a claim what the outcome is going to be. That's going to make settlement harder. That's going to make judicial outcomes more arbitrary. As well, worth reading because it's quite a powerful minority. What are the practical takeaways coming from guest and guest? Well, first of all, we do actually now have a definitive test for remedy, which is great because, as noted in the many decades that proprietary estoppel has been knocking around for in its modern form, we've never had an examination that says here is the principle. The principle is expectation-based, and that's good for claimants. So if you have someone to whom promise has been made, you can say to them that there's a good chance that the remedy is going to be on the higher end of perhaps the sort of cases that we saw historically. Unfortunately, it can still be a little difficult to determine. The practical application of the test does involve looking at expectation and then seeing whether it's out of proportion with the detriment. But given that we have yet to have a significant amount of cases responding to that, it's a little difficult to see how the courts are going to resolve that point. And that makes it a little difficult and risky to advise. One final implication, which might go just beyond proprietary estoppel, and what makes this perhaps the most important recent cases, is the fact that the minority judgment came out so strongly against too unfettered a judicial discretion, too easy a judicial discretion, arguing very much that proprietary estoppel ought to have a clear detriment-based solution that would allow for predictable outcomes. If this is an attitude that becomes applied more widely, then that might bleed out from proprietary estoppel into other areas of the law.
Thanks, Piers. The first case I want to look at is Zedra Fiduciary Services and the Attorney General. So this is better known as the National Fund case, and it concerned the appropriate application of funds which were held on charitable trusts which failed to be applied under the CPRE jurisdiction of the court pursuant to Section 67 of the Charities Act 2011. By way of very brief background, Mr. Farrer, who's pictured there, was particularly concerned about the national debt and how it had increased following the First World War. So he transferred £500,000 to Barings to be held on trust. And the aim was that that fund would, by the accrual of interest and by contributions from others who would be motivated by seeing this fund piling up over time, would then contribute to it. And one day it, along with other funds, would be one day large enough to clear the national debt. By the time this case came before the courts, it was decided that that aim could not be achieved, such that it failed to be applied under Section 67. And as you'll see on the slide, the matters which the court will consider are listed: the spirit of the gift, the closeness to the original purpose, and the need for the relevant charity to have purposes which are suitable and effective. So then rival schemes had to be considered. The first was the Attorney General's, which very simply said, primary aim of clearing the national debt cannot be achieved, therefore it should be used to reduce the national debt. And this was actually a secondary purpose of the original trust, which said that the trustees could apply the fund in reduction of the national debt in times of national exigency. The trustees proposed what might be considered a more creative solution, which was the income from the fund should be applied to charitable purposes within the UK as the trustee shall think fit. And in executing that, the trustees should consider schemes which would benefit the United Kingdom as a whole, would stimulate altruism in others. Again, that was tied to the fact that Mr. Farrer explicitly set up this trust to encourage others to contribute to it rather than just applying it immediately towards the national debt. So stimulating altruism in others was a crucial element of that, and that was what the trustees were proposing to do. And the third thing they then sought to do was to collaborate with and support other charities. So in the High Court, Mr. Justice Zaccaroli considered the three limbs under Section 67(3) somewhat in isolation and said that the Attorney General succeeded on the first and second limb, while the trustees' scheme succeeded on the third limb, but not sufficiently to outweigh the first and second limb, such that it was to be applied in reduction of the national debt. On appeal, then, Lord Justice Lewison wrote the opinion of the Court of Appeal. He said that the proper approach was to consider all of these matters, but that they couldn't be considered as sealed away from the other considerations. So when considering the spirit of the gift, that was coloured by the original purpose. So even though it is quite a nebulous concept, the spirit of the gift, it did have to be tied to the original purpose. So therefore, the spirit of the original gift was not just to stimulate altruism in others, it was to stimulate altruism in others towards the purpose of reducing or clearing the national debt. And the Court of Appeal didn't allow, well, was disagreed with the trustees' position that certain elements, such as encouraging altruism, could be stripped out. It had to be considered in an overall sense. On the second limb, then, closeness of purpose, that's where the trustees faced most difficulty. The closeness of purpose was the purpose to which the original gift was made, and essentially the Attorney General's scheme promoted the secondary purpose of reducing the national debt to the primary purpose, and the trustees' scheme would have no effect on the national debt at all. So the court concluded that the Attorney General's scheme was undoubtedly closer in purpose. Moving then to the third limb, purposes which are suitable and effective, this is probably where the trustees had the best prospect of success. They simply said that this was the Attorney General's scheme was neither suitable nor effective, but on the basis that it would have essentially no effect on the national debt. It would be a book entry against national debt, even though it amounted to about £600 million. By now, the national debt is about 2.3 trillion. So it would have no effect, was what the trustees sought to argue. When considering the suitability point, the Court of Appeal said suitability has to be determined with reference to the original purpose. And insofar as the National Fund reduced the national debt, it was suitable for doing so. And even though the effects would be minimal, it did what the original purpose was, which was to free up, however small, it did free up some funds, which the government could then decide to allocate as they saw fit. I think it was approximately £6 million of interest or so would be reduced as a result. So even though it's minimal, insofar as it did achieve that aim, it was suitable and effective. So the trustees' appeal was dismissed. But I think the main takeaway from this case is that even though the Charity Commission guidance essentially encourages creativity in considering schemes, this case really shows that you will be quite limited in what scheme can be proposed, because you can't separate the spirit of the gift or the effectiveness of the gift from the original purposes, such that that closeness to the original gift must remain in whatever scheme is proposed. So I think there is going to be some difficulty for any trustees proposing what might be seen as a more creative scheme, which the trustees themselves consider would be more helpful than what would actually result from, in this case, the alternative scheme.
And that takes us on to Naidu and Barton. And so this and the next case I'll be discussing, Ray and Rare, both deal with undue influence, but in two slightly different and interesting contexts. So Naidu and Barton, the background is a fairly classic mutual wills case, aside from the introduction of the son's undue influence. So in 1999, husband and wife each make a will. Each will provides that these two wills are intended to be in law mutual wills and leave everything to the one son, Mr. David Barton. However, after the husband's death in 1999, the wife goes on to make several subsequent wills. So there's one in 2005, one in 2006, and one in 2015, 2015 one being the last. That one leaves a different son as a beneficiary and executor. Now, ordinarily, the way that a mutual will would operate is to ensure that once one of the party dies, the other party to the mutual will is effectively bound to their promise that their wills be mutual. So from the death of the other party, they're no longer capable of revoking that will, and the executor under any future will would effectively hold the trust, the estate property on trust to be distributed according to the older mutual will. So that being quite unsatisfactory to the latter son under the 2015 will, he brought a claim for rescission of the mutual will agreement. Now, there are two sources of law on undue influence, which was the leading ground on which the claim was brought, pointing to the influence of the son who received under the 1998 will on his mother. One of those is inter vivos transactions, for which the leading case is Royal Bank of Scotland Metridge, and that citation is there on the slide. And that is effectively set out. Unacceptable conduct, which means consent to the transaction, ought not to be fairly treated as an expression of that person's free will. There are two ways that you could show that effectively. One is through actual undue influence, which is to show that there was some kind of active threat or pressure or something actively untoward that overrode the will of the person behind the transaction. And the second is presumed undue influence, which is the way in practice this most commonly ends up getting argued, which is to say that where a person has a relationship with the party making the transaction, and that relationship puts them in some sort of position of influence or ascendancy, and so they're in the position of a carer or a husband or a child, a parent, those sorts of relationships. And there's a transaction where you look at it and immediately you'd think, well, hang on, this is unusual. There's something about this that perhaps requires further thought. Then once you have those two elements, you can make a presumption effectively that there was undue influence. The burden is obviously still on the person alleging undue influence to prove the nature of the relationship and that it has the necessary aspects of ascendancy and influence. But once that point has been met and there is a questionable transaction, then the bar is rather easier. You can contrast this with testamentary dispositions, so undue influence in respect of wills, which is a much more difficult bar to meet. There's no such presumption there. There has to be such pressure placed on the testator as to overpower the volition without convincing the judgment. So it wouldn't be sufficient simply to say, look, the first son and the mother, there was a relationship of influence there. The mutual wills are a bit strange because they leave absolutely everything to him. And then because they're mutual and the father's died, there's no way to go back on that. That seems a bit strange. Therefore, we've got those two criteria. And the defendant's case was very much on his roots, was to say that, look, this should use the test for undue influence from testamentary dispositions. After considering the matter, the court came to the conclusion that the way mutual wills operate or work is that they are not in and of themselves testamentary dispositions. They are effectively a contract, a promise taking place during lifetime that on death crystallizes in the form of constructive trust, to say you can't go back on that. And the executor under the latter will, as mentioned, still receives as executor under that will, because wills can be revoked. It's simply that they were constrained to then dealing with it according to the terms of the previous will. So often handing it over to the previous testator. Because it was not a testamentary disposition, but simply, had an effect such that it sort of overrode testamentary dispositions, it was in itself a lifetime transaction, and the appropriate test was ettrage, and so presumed undue influence was sufficient. That was made out on the facts. The practical takeaways, one's been true for a while, but this really underlines it and puts several exclamation marks on it. Think very, very carefully before advising mutual wills. They're very vulnerable to challenge. And even if wanted, they're often not a good idea, because things do change. And even if your client says to you, look, I really think this will, this is the one for me, I'm going to stick with it forever. They may want to end up making changes later on. And if they absolutely push through, even through that, you might want to say, because these are vulnerable, consider some other form of trust, perhaps, that you could settle to be able to implement this. Secondly, the way to get around ettrage is to make sure that they have both testators have independent advice explaining the nature and consequences of the transaction. So make sure you sit down independently with both of the people involved in mutual wills. Don't just rely on explaining to one and be thinking that would be sufficient. You've got to take both of them through that process.
Thanks. The next case I want to look at is James and Scudamore. So the issue in this case is the circumstances in which a probate claim will be barred by delay. Very brief overview of the facts. The deceased executed a will in 1998. That was supplemented by a codicil, which was executed in 2002. He then passed away in 2010. The will and the codicil were approved in 2011 by the deceased's wife. In 2013, the claimant's son of the deceased obtained legal advice and alleged that the codicil was not valid, but he did not issue a claim at that point. The claim was ultimately issued in 2020, by which point the deceased's wife and one of the two attesting witnesses had died. And I think that will that's somewhat crucial when we come to the judge's view on matters here. So the claimant then sought to rely on the evidence of the surviving witness, who was the mother of the claimant's ex-partner. So she was the witness who was most likely to be favourable to his case in the circumstances. And as noted, the claimant had taken legal advice in 2013, which presumably, if it had been favourable, he would have issued a claim at that point. Instead, he didn't do so. He essentially sat on his rights, waited until many of the witnesses had died, and also, relied on a witness who was recounting events that had happened 20 years previously. So when it came to considering the issues, the first defendant said that there was this separate issue of separate doctrine, essentially, of probate laches. And this was a laches-like doctrine in the law of probate, which we can call probate laches for convenience. But the question here was not whether the equitable doctrine of laches applied. It was rather a separate doctrine which could do the same thing, but was not a product of the equitable doctrine of laches. So His Honour Judge Matthews reviewed extensive authority going back about 200 years and considered that he could make a number of propositions. The first was that a deliberate failure to intervene in probate proceedings can lead to a party being bound by the result. Explicable delay on its own will generally not be enough to bar a claimant from taking probate proceedings, such that if there was an obvious reason why proceedings hadn't been issued, that would usually not be enough. However, unjustified delay, possibly on its own or combined with a waiver of rights, will serve to bar a probate claim. And where that delay has led to others' detrimental reliance, such as the distribution of an estate, subsequent claims will be barred. So I think the key takeaways on this point is the importance of prompt action, especially in those circumstances where there has been legal advice. So this is what His Honour Judge Matthews focused on in much of the judgment. When the claimant had written to the deceased's wife in 2013, she had then, explained exactly how the codicil had been executed. Then nothing happened. She then died. She obviously can't give evidence then at this trial. And the fact that he had taken that legal advice and waited 7 years before actually issuing a claim meant that this claim was was barred by the doctrine of probate laches. When considering advising clients, I think it's important to bear in mind that death of witnesses will mean that this presumption of due execution of wills will be very difficult to rebut. In this case, the fact that even though the surviving witness strongly supported the claimant's case, the death of the other witnesses who would likely have disagreed with the evidence of the claimant's witness means that that presumption is very difficult to rebut. I think it's also worth noticing that you'll often, when you have a will, you'll often have the witnesses being people of a similar age, so they therefore may not be blessed with longevity in many cases. So I think that's an important factor to consider when you wish to move. You wish to move quite promptly, because those witnesses may die, or they may, end up lacking capacity at a certain point, or indeed they'll just have difficulty recalling events as you get further from the point at which the will, or in this case, the codicil, was executed. Another important consideration, I think, is the concept of detriment in probate laches. So the deceased wife had, of course, she died before the claim had been issued, but she had actually executed a new will in 2014, which left a substantial part of her estate to the claimant's children. So it's easy to see how she may not have made that will, or would have revoked that will, if the claimant had issued this claim. So she had acted to her detriment by, assuming that those 2013 issues the claimant had raised had been dropped, essentially. And this was now at a stage where she couldn't change her will anymore. So the detrimental reliance need not be of a party to the case. Here it was just the deceased's wife who may have acted differently. The judge went beyond saying that there was prejudice to any particular party and said that the delay had consequences for the administration of justice generally, because the best evidence in this case, so that is, the evidence of the deceased wife and the other attesting witness, had been lost. And also that the surviving witness, her evidence was going to be much less persuasive in circumstances where it was now 20 years since the codicil had been executed. Overall, I think it's worth noting in this case, at least, that even if this doctrine of probate laches didn't apply, His Honour Judge Paul Matthews went on to say that even if all of that had been wrong, he would have applied the equitable doctrine of laches to bar the underlying action, which was against beneficiaries of the deceased wife estate. And even if that was wrong, he went on to say that he didn't believe much of the evidence and considered that the codicil had been validly executed. So I think the main point in this case is essentially this possibly new doctrine bringing together some of the older cases of probate laches, and it highlights the importance of acting quickly in probate proceedings.
And very briefly, our last private client one, so thumbs up for the insolvency people very shortly. Rare and rare. An interesting one, not so much for the law itself, but for how it was applied to the facts, and perhaps a slightly surprising outcome of the facts. So Anna Rare dies in 2016. She leaves 3 sons and 1 daughter, Rita. She has many health problems, which leave her in a very frail condition and dependent upon her children for care. Principally, that's Rita. Her son certainly suggested they contributed, although the extent of that was disputed. Anna makes a will in 1986, very simple 1-page document, not a lot to it. The drafting is very plain, leaves her property in 4 equal shares to her children. That is then changed in 2015 when it is redrafted substantially with professional help, made a lot longer, etc. And the big change now is, while the residuary estate still is split into 4 equal parts to go to the children, the house, a very substantial part of her estate, goes to her daughter Rita all of a sudden. Now, what's notable about the facts on this is that the will was drafted and explained to Anna in the presence of a competent and experienced solicitor, the court considered, and witnessed in the presence of Anna's GP, who had also conducted a capacity assessment. And so perhaps conventionally, if you had all of those boxes ticked, you'd be thinking this is going to be fairly bulletproof to undue influence at this point. Nevertheless, and as you've guessed, the reason we're focusing on this is that was not in fact the case. Returning to the key authorities, the court looked particularly, I think, to Schrader and Schrader, which effectively said that, look, when you have undue influence cases, often the only evidence is going to be circumstantial. They are arising often out of power imbalances, relationships. There are things that are happening behind closed doors, things being said that other people might not be party to, pressure on often vulnerable elderly people in the home environment. And often, you effectively have to figure out where the light is from the shadow when seeing whether this is there. So you're looking at all of these circumstantial factors and seeing where the weight of them comes out in many of these cases. Now, there were a number of points that in this case were thought to be factually critical points for finding undue influence. I've picked out the 6, which I think are really pertinent and worth remembering. And they're firstly that when it came to cross-examination, the judge's impression was that Rita was a very forceful personality, and that contrasted with Anna's historic frailty and vulnerability. Second, Anna's dependence on Rita. So the solicitor in the matter effectively told Anna, when you come to have this drafted, you shouldn't turn up with Rita because that may present problems later on. Nevertheless, Anna effectively said, look, I need Rita here. It's important that she is here for me. And that was the case, even though the solicitor considered that by and large, Rita didn't chip in particularly much during the conversation about the will itself. It was mostly driven by Anna. Thirdly, the timing of the change of will. It comes almost immediately after the sons reduced their presence in Anna's life. So I think the inference there is that, as soon as there's no one to kind of act as a check on Rita's influence, that's the moment that you see this will popping up. Fourthly, significant that it was Rita herself that made the arrangements for Anna to see a solicitor, even if Anna did express that's what she wanted. Fifthly, the complexity of the 2015 will was obviously very different to the prior will, even though the core substance it was very similar, giving it to 4 kids versus giving one bit to 1 kid and the rest to 4 kids. It's not a huge change, and yet the sort of tenor and voice of 2015 will was very different. And then finally, the fact that the will was effectively kept under wraps, which the inference there being that Rita didn't really want people to know about it because it would have hinted at the undue influence she was exercising over her mother. So despite all of the steps taken by the solicitors in this case, undue influence was found. That gives some really important practical takeaways in these cases. Firstly, these are unpredictable. Rare is notable because there's quite a few cases that didn't fall the same way. So when you're considering litigating in these, you have to be quite honest with the client that it's actually really difficult to predict the outcome of these cases, and that could be quite a good reason to consider settling. But also, it's very important at the start when you have a client coming to you who says, I want to redo my will, and it's perceived as very much favouring one child, that you say to them, look, you really can't bring that particular person along, even if you really rely on them. And I'm sure that that's really what you want. There's a real risk that it could invalidate the will. Set that out very plainly, very clearly. Check if there is anyone else that they feel they can rely on at all, who's not necessarily within the terms of the will. Because if Rare and Rare's reasoning or margin of judgment catches on, then there could be a lot more challenges in these sorts of cases. And I think that brings us quite nicely to insolvency.
Yes, thanks, Piers. So the first case I want to look at is Manley Partners and White. So the issue here is whether the court can and indeed should compel a judgment debtor to draw down pension benefits under an occupational pension scheme. So very brief overview of the facts. Mr. White had been a director of Lloyd's British Testing Limited. Manley was the assignee of claims that the respondent had breached fiduciary duties owed to the company by causing it to make payments in the 20-month period prior to it entering administration. The payments in question included the purchase of 2 Bentleys, 2 Lamborghinis, a Porsche, and a helicopter. So Mr. White was definitely living large, at least for a while. And Manley had then obtained judgment against Mr. White for a sum of just shy of £1 million, and nothing had been paid towards the judgment debt. However, Mr. White was the sole beneficiary of an occupational pension scheme, which had been funded entirely by the company and which was worth about £800,000 and was generating about £60,000 a year of income. Manley then applied for injunctive relief under Section 37 of the Senior Courts Act 1981 for an order that Mr. White be required to draw down his pension benefits to enable him to satisfy the judgment debt. Mr. White sought to resist that application on the basis of Section 91 of the Pensions Act 1995, which in essence provides that the court shall not make an order the effect of which will be to restrain someone from receiving the benefits of their pension. It's worth noting in this case, none of the limitations in subsection 5 of Section 91 applied. So this was not completely novel territory, of course. In Blight and Brewster, Batchy and Green, their parties had been required to draw down their pension benefits. However, both of those cases involved fraud. And in the latter case, even though Section 91 had been considered in Batchy, His Honour Judge Hodge, KC, in this case, didn't consider that binding because it had been the subject of a concession by counsel in that case. The fraud, non-fraud distinction was handled quite shortly by the authority of Brake and Guy, which affirms that there is no principal distinction between fraud and non-fraud cases, because the issue is the use of a pension preventing, in this case, a judgment creditor getting their just deserts, essentially. The holding on Section 37 was that there was no bar to injunctive relief under Section 37, and it was only the question of Section 91 that could save Mr. White in this scenario. The court clearly had the necessary jurisdiction to grant the injunction sought, requiring Mr. White to draw down his pension benefits unless it was barred from doing so by Section 91. And I think it's the Section 91 point that's the interesting one. The court essentially took what is a formulaic or a view concerned with form rather than substance when considering Section 91, because the court considered that so long as the funds were drawn down into an account in Mr. White's name, he was not deprived of his pension benefits. The fact that those funds would immediately be used to satisfy the judgment debt was irrelevant. So I think it is it's judgment more concerned with form than substance, because the practical reality is that Mr. White was then going to lose the entire pension pot. It is worth noting that the interpretation, as I've said about the interpretation, but the relevance of wrongdoing here. So the court considered it a highly relevant, highly important factor that the assets in that pension fund had been derived entirely from funds which had been provided by the company, of which Mr. White had breached duties which he owed to that company. And that was an important consideration in the exercise of the discretion. I think what this case does, it gives us clarity on Section 91, but it also ties together some strands that had been applied in different cases but hadn't been pulled together in this way. And it highlights that pension assets can be a valuable asset for judgment creditors seeking to enforce, however, subject to the caveat that His Honour Judge Hodge, KC, in this case, emphasised the importance of that link between the assets in the pension fund and the company of which against whom Mr. White had breached his fiduciary duties. And that connection is likely to be important when considering whether the Section 37 application will succeed.
Yeah, it's been really interesting that watching sort of over the last decades, the sort of bulwark protection that pensions have has slowly been eroded. Brake and Chevington called Estate Limited. So a very interesting one here, because it's perhaps a long-awaited clarification of standing of persons to challenge acts, omissions or decisions of the trustee of the bankruptcy's estate. The facts for this are a little particular, so you'll have to excuse me while I run through them. They are set out on the slides, but Mr. and Mrs. Brake and a company known as Patley Wood Farms, which is an investment vehicle, are in a partnership, and they provide effectively an accommodation business. It all goes sour, and the running of the partnership ends up in arbitration. There is a judgment for a significant amount and costs made against the Brakes. And later on, this will lead to the dissolution of the partnership, a fact which is going to come back later. Now, the property of this partnership included a farm introduced to the partnership in 2010. And next to this farm is a cottage. And both of these are held in the name of the Brakes as partnership property. When the partnership goes into administration and then liquidation, the farm is sold eventually to Cheddington, who then have the farm. And this obviously gives Cheddington an interest in acquiring the adjacent cottage, and they approach the liquidators of the partnership about that. Now, Cheddington's eventually successful in their bid, but their main competitor was in fact the Brakes themselves, who were not bidding as the Brakes, because as a result of the judgment and costs against them, that actually ended up going into bankruptcy proceedings. But they were bidding as trustees and using the funds of a family settlement fund, which we'll call the Brake Trust for the time being. And Cheddington's bid is the better of the two, and Cheddington is to receive the cottage to go with the farm. Now, this ends up with a fairly complicated situation where the liquidators have the partnership's interest in the cottage, but the legal title on the cottage remains held by the Brakes. But the property of the Brakes more generally is to an extent still being dealt with by the trustee in bankruptcy. So there's a bit of a mix up there. And the arrangement that's come to deal with this is that Cheddington will lend money to the trustee in bankruptcy. Trustee in bankruptcy will buy the interest that the partnership may have in the cottage from the liquidators. Then it's simplified to just legal name Brakes, beneficial interest trustees, easier to deal with. And in 2019, on that basis, the trustee grants a license to Cheddington to make use of the cottage, and Cheddington's employees and agents go in and they change the locks, effectively evicting the Brakes, who from time to time were in possession of the cottage. So now we're through that fairly complicated factual background. Section 301 of the Insolvency Act 1986 is a broad provision, and if read literally, it would have very, very wide application indeed, because it simply says if a bankrupt or any of his creditors or any other person is dissatisfied by any act, omission or decision of the trustee of the bankrupt estate, he can apply to the court to have something done about it effectively. Now, because that is so wide, the courts have naturally said that in order to make this application, you're going to need some kind of standing, as in Hamid and Morris. The way that the trial judge dealt with the application by the Brakes, who put in a Section 301 application to say, look, the trustee shouldn't have been able to deal with the property as they had, is to break them down, the application to deal with the different roles of the Brakes. So in their role as trustees, they had nothing to do with the bankruptcy. If the trustees had been some other people who didn't happen to have also being the former members of the partnership, then it's very plain that they would have had no particular interest in what the trustee of the bankrupt estate was doing. The second role that the Brakes kind of came to the party as was in their role as the bankrupts. Now, bankrupts obviously will sometimes have an interest in what the trustee is doing, because sometimes there is a surplus in the estate. And if the trustee, performs their job poorly or doesn't take into account things they should, then the surplus might be diminished or even cease to exist, which prejudices the bankrupt. Equally, and probably the more common situation, is that because they've been made bankrupt, it's precisely because that there is no surplus expected to be realised from the estate. So if there had been a surplus, then they'd have been capable of not being made bankrupt in the first place. And if there is no surplus in the estate, then it doesn't really matter to the bankrupt how badly the trustee deals with things, because they weren't getting anything anyway. So, of course, a great interest to the creditors, but and they would be entitled to make an application, but not the bankrupt. And the trial judge noted that following Engel and Perry, occasionally there's situations where there might be a special interest, but broadly speaking, the bankrupt needs to show that there'll be a surplus before they have any interest. This gets up to the Court of Appeal, and the appeal is very narrowly allowed on the ground that Cheddington had evicted the Brakes, as it turned out unlawfully, because they only had the licence, and that was based on possession proceedings at the time. And the licence might not have been granted if the trustees had acted differently, And this represented a legitimate and substantial interest in the relief sought, sufficient to give the breaks standing to make an application. So because the nature of the relief would have impacted them, and because it was being dealt with by their trustee in bankruptcy and they were the bankrupts, the Court of Appeal considered that that would be an example of the special sort of interest that was raised in England Perry. This is quite concerning because that's quite a broad interpretation. It raises the worrying prospect that lots of trustee actions are going to get interfered with. This eventually bounces up to the Supreme Court, and we get a very clear workable judgment that says, look, the interest has to be an interest specifically derived from their status as bankrupts. That's the basis on which they have standing, and not a general interest in the relief plus the possession of bankruptcy status. Their interest in, for example, the license not having been granted the way it was, well, that is derived from their role in possession, which didn't necessarily have to cohere with their role as bankrupts. It could have been a third party that had been in possession, and they certainly wouldn't have had the right to interfere with the bankruptcy. So on that basis, the appeal was allowed. Practical takeaways: one, much lower risk for trustees in bankruptcies. Although to an extent you do still have to consider that there may be a special interest, for the most part, you can simply go, is there a surplus? And if there isn't, well, okay, we really don't have to worry about the bankrupt so much. Secondly, examples of the special interest were identified to clarify those sort of rarer situations. One particularly notable one is applications for annulment, because when you're going to annul, the amount of money you need will obviously vary depending on how well the trustee has or hasn't dealt with what you have. And so there is an interest there. So quite useful clarification.
Continuing on the annulment vein, the next case I want to look at is Khan and Singh Sal and Habib Bank. So the basic issue at play here was the circumstances in which the court will annul a bankruptcy order under Section 2821A of the Insolvency Act, and the extent of the discretion which the court is afforded in doing so. So this was a second appeal. Mr. Khan had been made bankrupt on the petition of the second respondent. The annulment application was heard. District Judge Hart considered that although the bankruptcy order should not have been made on the basis that the debt was disputed and it was a secured debt when the petition said it was an unsecured debt, she declined to annul the bankruptcy. She weighed up several circumstances, most notably that Mr. Khan was undoubtedly insolvent. Mr. Khan then appealed. That appeal was dismissed, and the second appeal then raised the issue on the extent of this discretion under Section 282. Mr. Khan submitted that as the debt was disputed, the court had no jurisdiction to make the bankruptcy order, and thus the bankruptcy should be annulled as of right in those circumstances, or at least there must be exceptional circumstances to refuse to do so. On the jurisdiction point, the court disagreed with the way this was framed by Mr. Khan. Lord Justice Newgee looked and distinguished those jurisdictional points from common practices of the court. And he drew an analogy with winding up proceedings, where as a matter of practice, the court will not make a winding up order on the basis of an undisputed debt. But this is a matter of practice and not of jurisdiction. The same is true in bankruptcy proceedings, is what we can derive from this case. And the approach is, again, one of practice and not jurisdiction. Looking at the exceptional circumstances test that Mr. Khan sought to rely upon, that basically where the bankruptcy order shouldn't have been made in the first place, there must be exceptional circumstances to decline annulment. Obviously, the first thing to note is there's nothing about exceptional circumstances in Section 282. In fact, Section 282(1)(a) is clearly one of pure discretion. However, the most likely consideration is always going to be one of the applicant's solvency. So if the debtor cannot pay his debts anyway, there isn't going to be any real benefit to him or anyone else in annulling the bankruptcy, subject to a limitation point, which is considered later, and I'll come to that in a moment. Firstly, on this exceptional circumstances, the court concluded that there is no exceptional circumstances test, and that for an application to be refused, an application for annulment to be refused, there must simply be factors weighing against the granting of the bankruptcy order. And as a lot of the case law shows, the most significant thing weighing against annulment is likely to be actual insolvency. So on the limitation point, this was not, it didn't have to be considered ultimately in this case, but it's notable that in the High Court, it had been considered that as the effect of annulment is to, make it as if the bankruptcy order had never been made, wipe slate clean, limitation ran as normal through the bankruptcy period. But although submissions weren't heard on this point, Lord Justice Newgee raised serious concerns about this interpretation, because the real risk there is that an individual may find that their claim is statute barred after an annulment order has been made. This would be someone who could have proved in the bankruptcy, and indeed perhaps did, but they'll then find when the bankruptcy annulled that it was annulled, that time has continued to run and their claim is then statute barred. And there is a real risk of injustice if that remains the case. So I think that's an issue that's very likely to be revisited. And I wouldn't be surprised if the High Court's view on the limitation point is reversed.
Yeah, back to you, Piers. Fantastic. So last one from me for today, and we have Investbank PSC and El Hussein. An interesting one because it deals with a remedy that, in my view, is underutilised. It's certainly a useful one, and that is Section 423 of the Insolvency Act 1986, transactions defrauding creditors. So factual background very briefly, Investbank gets a judgment in Abu Dhabi against Ahmed Al Husseini, who is the head of the Al Husseini family, who constituted most of the other defendants, and a business magnate, the other defendants being various connected companies. And the bank seeks enforcement against various UK assets, particularly a number of London-based properties and the sale proceeds of those properties, as well as some monies held by a Lebanese company. Now, on a technical point, this was strictly argued on the basis of real as opposed to fanciful prospects of success, effectively the summary judgment test. And that's because at the point these arguments were made, the court was dealing with an application by the bank to amend its particulars to add a claim, a set-aside challenge to permission given to the bank to serve out of the jurisdiction, and a summary judgment by one of the defendants on one of the points. But these all effectively boiled down to the same key point, and we can sort of ignore that for the time being, because that key point is on the real as opposed to fanciful prospects of success test. Is Section 423 going to work at all? Does it deal with the sort of transactions this is dealing with? And Section 43 is on this slide here. I won't run through it now because we're out of time, but when you do get the slides, do feel free to go through it. It effectively says that when you, as a person, enter into a transaction where you give something away or give it away at an undervalue, and you have an intent that that's done to prevent a claim or potential claim against you from being satisfied, then the court can take steps to undo that. And what was happening here was the bank was effectively saying, look, there's a bunch of connected companies. They've taken steps to put assets out of our reach. We'd like those transactions undone. The defendant challenged that on two bases. Firstly, they said that a transaction, in the sense used by Section 43, doesn't extend to dealing with assets not beneficially owned by the debtor. And they applied Clarkson v. Clarkson, which came to that conclusion in the context of other similar provisions of the Insolvency Act that apply in the bankruptcy and liquidation scenarios. And secondly, even if transactions did extend to that, a person undertaking the transaction was not a debtor, which is the language used by Section 43, for the person attempting to put things beyond the reach of a claim. You are not a person for Section 423 if you were merely the instrument of a company. So the person who, a company needs to sign a document to carry out its acts or to undertake communications on behalf of the company, if your act was in some way the act of the company. Now, the trial judge rejected the first one and accepted a very narrow version of the second one, which was effectively to say that if there's a real kind of directing force behind a debtor in the company, well, then that probably does fall inside section 43. But where they are a mere instrument of the company, then that act should be attributed to the company because of the principle of separate corporate legal personality. So how was this dealt with on appeal? Well, the defendant's appeal was refused. Grounds quite basic. The language of the statute was very broad, and particularly in respect of Clarkson v. Clarkson, the view was that this ought to be restricted to the insolvency and bankruptcy cases. And Section 43 deals with a wider context than that. It's not limited to the bankruptcy and liquidation context in quite the same way that the provisions dealt with in Clarkson were. But secondly, the claimant's appeal was allowed. And there's quite an interesting discussion of the disattribution heresy. And if you fancy some homework, you can see the article that gave rise to the court's examination. And it effectively said that there's a very important difference between saying that when a person does something, that act is to be considered the act of the company, because obviously a company by itself can't do anything without the people to. A company can't walk into a shop and sign something. It needs sort of a physical person to go and carry out its actions. We identify those with the company and say they're the act of the company. There's a difference between that and saying that because a particular act undertaken was an act of the company, it is therefore also not an act of the agent. And the second one, disattribution, didn't necessarily follow identification. So there are effectively some situations where an act might be both an act of the company and of the agent. And it was considered that the context of Section 43 is to provide broad protection. It's not a case where Parliament had had in mind that if you settle a very complex corporate structure and say, look, I'm just doing what the company told me to carry out, nothing to do with me, Gov, that you'd be able to get away with it. And so the court said that no, actually, even acting merely as an instrument might be sufficient to fall within Section 43, and that would have to be considered at a later trial. So practical takeaways, one, very welcome judgment, effectively saying the court isn't going to excuse people using these complex corporate structures to try and avoid claims, and you should consider use of Section 43 because it might help you even where, for example, conventional remedies like tracing might not, because you're able to undo the whole transaction. But if you are doing that, then just bear in mind the second one, the second point there, which is you do have to show intent to effectively put things beyond the reach of claim. That may be difficult to prove. Which takes us on to our last case.
Thanks. I'll try to run through this one very quickly. It's Dinaxi and Cooper. Very brief factual background. A minority shareholder in Blackpool Football Club had obtained a buyout order in 2017 against Dinaxi and Mr. Oyston, who was a director of Dinaxi. Less than a third of the amount due under that buyout order had been paid. The court then appointed receivers by way of equitable execution over the footballing assets. And the case ultimately concerned a negligence claim against the receivers of Blackpool Football Club, which and the extent of the immunity they enjoyed by those receivers who had obtained approval in what's known as a public trustee and Cooper application over the assets over which they'd been appointed. So the receivers had obtained valuation evidence which had reiterated their view that the assets were interconnected and disaggregating them would have a detrimental effect on their value. And shortly before what's known as blessing application, Mr. Oyston had filed a witness statement in which he purported to reserve his right to comment on the marketing and valuation of the footballing assets at a later date. The receivers were understandably concerned about this and responded to say that they intended to seek directions that the sale of the assets be completed. And it was incumbent upon Mr. Oyston to raise any concerns he had at that stage, because if he didn't, of course, the sale was likely to go ahead in light of the evidence. Marcus Smith J. entertained the application as the decision was undoubtedly a momentous decision and justified the approval of the court. He concluded that the sale proposed was a proper one and should be sanctioned by the court. In January 2020, then, Dinaxi issued a claim alleging that the receivers had negligently breached their duty of care and had sold the footballing assets at an undervalue. The interesting thing here is that none of the previous cases really had dealt with the extent of the immunity, which was enjoyed by, in this case, the receivers. So the receivers sought to argue that they had blanket immunity. They were covered from any claim which might be made subsequently, whereas Dinaxi alleged that the immunity only covered their equitable and fiduciary duties rather than a common law duty of care and negligence. And that was essentially the main point of argument in the Court of Appeal. The Court of Appeal thought that this was misdirected in many ways, and they said this equitable versus common law distinction is not the relevant one. Rather, the immunity which flows from an approval decision is necessarily tied to the nature of the review that had been conducted by the approving court. So there is no blanket immunity, and there is no equitable immunity from equitable claims. Rather, the immunity extends to the specific issues which have been considered. And essentially, Lord Justice Snowden in his judgment says that this immunity is shorthand for the bar and subsequent proceedings, which results from an issue estoppel. Because Mr. Oyston and Dinaxi and those connected to the company had the opportunity to raise their concerns with the proposed sale at the approval hearing, they were then barred from seeking to subsequently relitigate that issue against the trustees and the office holder. So I think there's a very useful and very brief concurring judgment from Lady Justice Aspin, where she says essentially, one size does not fit all. You can't say the precise extent of approval, or immunity, which office holders will receive. It's going to depend very specifically on what has been decided and what has been before the judge hearing the sanction application. Lord Justice Snowden also said that both parties and judges should identify as clearly as possible the issues which the court is deciding, and it is in that way that you can determine whether a subsequent claim is barred or not. So practical considerations then going forward, I think really it's the importance of the specifics, specifically what do you want to be covered for when making that sanction application, because that will be what determines whether the office holder subsequently has immunity or not. The court may be unwilling, it's recounted in many of the cases that the court is not a bomb shelter. You can't just seek approval, seek immunity from all claims. You have to be quite specific in what you look for. And it really shows that these cases going forward will be very much to be determined on a case-by-case basis. So that concludes our top 10 cases. I'm overrun by too much. So I'd just like to say on behalf of both of us, wish you all a good festive break, and definitely keep an eye out for our 2024 junior program. We'll have a packed program ahead in 2024. So all the best from both of us.